When you're doing a 1031 exchange, you cannot expect your qualified intermediary to do everything for you with regard to everything. There are other professional advisors that are there to help you do other things. For example, you need to have a good title company to do the closings, to put the window dressing on the settlement statements to articulate what's really going on with the exchange. I like working with Stewart Title a lot. They do a great job. Another, or other title companies for that matter. But you need to work with a good title company. That's part of your team. Another part of that team is your real estate agent. Your real estate agent can help facilitate the smooth transition of your property. One thing that we often suggest when you negotiate your purchase and sale agreements with the buyer of your relinquished property in particular is to include a strong affirmative cooperation clause in the contract that says seller is doing a 1031 exchange, buyer agrees to reasonably cooperate and will sign a notice that they received a required document that pertains to the seller's assignment of the rights to the intermediary. It's really no skin off the buyer's nose, but occasionally you have buyers that will drag their feet, create drama unnecessarily at the closing. If you don't have this provision in your contract, the buyer may use that as an opportunity to try to exact a concession. I'm not signing this notice unless you give me a $500 discount or a credit. We've seen lately, unfortunately, a trend where buyers act badly at closing. If you have this clause in the contract, you can talk to your counterpart, the real estate agent on the other side, quietly in the hallway and say, hey, look at page 3 of the purchase agreement right here. It says you will cooperate, you will sign this notice. Let's not make it a big deal out of this, right? But if you don't have that clause, you can get in trouble. Same thing goes for the replacement property. You want to have the same kind of provision in the replacement property contract that the seller will cooperate. But I don't like to put the clause in the initial offer. If I tell the seller, hey, I'm in the midst of a 1031 exchange and I'm trying to tie up a replacement property, but I want you to give me a big price reduction. If you know I'm in a 45-day hurry to get a property identified, you're less likely to negotiate with me if I give away that valuable detail that I'm in the midst of an exchange. So when I present my first offer to you, it's going to be vanilla. No references to a 1031 exchange. Once we settle on the price and the terms, then out of the briefcase comes my addendum. Oh, I also would like to include this page regarding my ongoing 1031 exchange. There are farmers in Worthington, Minnesota that are very quiet about what they're doing. They don't want their neighbors or anyone to know they're doing an exchange because they know the price will go up on that property that they're dead set on getting. They come all the way to downtown Minneapolis to deal with me because I'm not in their community and I'm not going to tell anybody at Hardee's, hey, did you know that John's doing an exchange? Oh yeah, he's got hundreds of thousands of dollars with me. You should raise the price. So we're very discreet. The other part of this equation is the accountant. At the end of this process, there is a Form 8824, which is not an easy worksheet to fill out, particularly when there's multiple relinquished properties. Your accountant is going to report how these puzzle pieces fit together. And guess what? The IRS is going to know that you sold a relinquished property because when you dispose of the relinquished property, the title company or the law firm or the party that's responsible for that closing has to ping the IRS with an electronic filing called a 1099-S. So they're going to know that you sold a relinquished property, and they're going to know what your sale proceeds were. So they're going to be alert, like, hey, what's going on? The 8824, prepared by the accountant or tax preparer, connects the dots between the property that was sold and the property that was purchased and provides some critical details, like when did you identify, when did you close, when did you acquire, what were your costs of the transaction. I also want to mention that the banker is the most probably, he who has the gold makes the rules. You know, if you're trying to lever up and buy a more expensive property, having a nimble, creative banker can be very helpful. There are bankers that act almost like consultants, consiglieres. They will help their clients, even before the client knows they have a problem, to identify the opportunity to defer the taxes. Those bankers are special. Those bankers see the potential tax liability and help their clients figure out how to negotiate the process to not having to recognize those gains. I like working with those bankers because they get it. The banker can also be your friend in making sure that you redeploy all of your equity. When you sell your relinquished property, let's say that you got $700,000 with me as your intermediary. Some bankers will say, you know what, you qualify for $1 gazillion in financing. We're going to lever you up to the hilt, give you all the borrowing that you can take. But your banker, if they're on your side, is going to first get your 1031 funds redeployed, because the purpose of giving you the tax deferral is that you're not cashing out. We have to redeploy all of your $700,000 first, and then and only then do we borrow money over and above that to complete the purchase. We do not want there to be a settlement statement that shows cash to buyer or borrower, because that would result in you getting boot. We're going to have a slide about boot in a little bit. Legal counsel. Having an attorney that understands what a 1031 exchange is incredibly important. And for lenders that are doing sophisticated loan transactions, having sophisticated lenders counsel that also understands what a 1031 is can be very helpful. When the attorneys work together to solve the problems and get the deals done, everything works so much smoother. But you all have to be on the same page and not dig your heels in about persnickety stuff that's not that important. All right, anyone else that I'm missing on this list of people that your client should have? Oh yes, the humble QI. The administrator that prepares the paperwork and conducts the 1031 exchange. A qualified intermediary is authorized under the Treasury regulations and is the only person on this list who is not deemed to be the agent, the patsy, the flunky of the taxpayer. If you are going to have somebody that act as your straw man to acquire property or to hold your proceeds, the appropriate party is the qualified intermediary, who is not your agent. Let's just talk for a second about who cannot be your qualified intermediary. My wife? Your wife is a related party, right? You file a 1040 with your wife. Probably she's related. Yes, she is. Your mother and your father, your ancestral and your lineal descendants, your children, are also too close to home. They cannot be your intermediary. Your attorney is your agent. You have a fiduciary obligation to look out for your client's interests. You can't be their intermediary because you're supposed to be a neutral third party when you're an intermediary, unbeholden Same thing with your accountant or your employee. They can't be your agent. Your real estate agent is also an agent. They have an agency arrangement with you. They are disqualified. Why am I making a big deal about this disqualified party, related party issue? Why am I bothered by that? Well, recently there's been a trend where some qualified intermediary companies are entering into revenue sharing arrangements with disqualified parties. If a qualified intermediary enters into a partnership, joint venture, revenue sharing arrangement with a disqualified party, they've just disqualified themselves as well from being your intermediary. So you got to be careful that you're actually working with an intermediary that isn't putting their foot in the bucket of disqualification by some under-the-table arrangement with a disqualified party, typically a real estate agent. By the way, also RESPA, the Real Estate Procedures Act, makes it against the law to pay kickbacks on residential transactions, so that would be transactions up to 1 to 4. And there are various other state rules prohibiting that practice. But I just want to mention to you that we don't pay kickbacks, and we always maintain that we are not going to be a disqualified intermediary. We are a qualified intermediary, and we represent that in our documents.